today's event, we have candidates for the Ohio Supreme Court to discuss judicial philosophy. And our format is we have Maurice Thompson, who's the immediate past president of our chapter and who's the executive director of the 1851 Center for Constitutional Law, which is today's event's co-sponsor. He'll be the moderator. We plan to have time for questions as well from the audience. We have Justice Robert Cupp and Justice Terrence and William O'Neill, and we believe Mike Skindell is on his way. So we'll go ahead and get started. Maurice?
Thanks, Joe. As Joe indicated, State Senator Skindell is driving in from Toledo. He's on his way, so what we're thinking is we allow everybody to introduce themselves, and maybe he'll show up just in time to be last if things work out all right, and if not, we'll keep moving. As Joe indicated, sponsors of the Federalist Society, the 1851 Center, my organization. Both are organizations that largely seek to limit government and advance constitutional rights. 1851 in particular litigates for liberty and often ends up in the Ohio Supreme Court, so it's a nice honor to be able to turn the tables and actually ask the judges some questions instead for a change. Although I don't think I'm going to make them sweat because that would be bad for my future career. So we're going to play it, you know, pretty neutral here. Importantly, both 1851 and the Federalist Society are 501c3 organizations. So in other words, they don't endorse any candidate. Nothing that I say today or no question that I ask or anything else that goes on here should be construed as an endorsement of any candidate, any party, or any particular position. And with that in mind, we're thrilled to have the candidates here today. Thank you to the justices and to the candidates for coming and for taking on these substantive issues that make a difference in Ohioans' lives. And it is one of the great benefits of an elected judiciary that we have the opportunity to interface with Supreme Court justices and candidates in this kind of forum. So we hope that I don't let the opportunity go to waste, and if any of you have questions, that you won't let the opportunity go to waste either. This event is being videotaped, so please bear that in mind, and will no doubt be viewed by many more people on video than here today. Some quick housekeeping matters that I think are important just before we get started. The candidates are running for 6-year terms to be one of 7 justices on the court. And there have been a lot of questions about this, so let's clear the air on this. The Judicial Code of Conduct, Canon 4, the Commits Clause, prohibits judicial candidates from making statements in connection with cases, controversies, or issues that are likely to come before the court, make pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties of the judicial office. However, the drafters of that section, in order perhaps to save its constitutionality from the First Amendment, have added the following. Pledges, promises, or commitments must be contrasted with statements or announcements of personal views on legal, political, or other issues which are not prohibited. So our questions are oriented towards those personal views on legal, policy, political, philosophical issues, and any questions that anybody in the audience asks should also be oriented in that direction rather than asking any of the candidates anything that might amount to a commitment. But the candidates can't answer those former kinds of questions. So here are the rules of the road for today's forum. First, everyone should know that the candidates were each supplied with these questions several days ahead of time. I will ask questions, typically asking all 4 candidates to answer the same question. I will follow up if something interesting is raised that requires a follow-up, and I will give any candidate an opportunity to respond if I feel like one of the other candidates has implicitly or explicitly attacked them on their views. However, I would ask the candidates to try just not to do that and to focus on their own merits to speed things up and to make this more efficient. Each candidate will have 2 minutes to answer the questions that are asked. My colleague Eric Murphy, an associate at Jones Day in Columbus, will be keeping time, and he will hold up this sign that says 2 minutes. Mr. Murphy also occasionally has cases before the court, so he's very nervous about having to hold up this sign and having to enforce this if you don't listen to him. So please try to make him feel better about his job by keeping your answers to 2 minutes. However, if you're in the middle of an important thought, please do feel free to finish that thought. We're not going to cut your legs up right at the 2-minute warning. Or the 2-minute time limit, I should say. However, for the first question, you only have 3 minutes to introduce yourself and your judicial philosophy. We are going to take questions from the audience. For audience members, there are some cards here that we will take and pass around. If you have a question, write it down on the card. If you want to remain anonymous, I can ask your question for you. If you want to put your name on the card, we can come to you and have you ask the question. So it's entirely up to you. We'll rifle through those as we're coming to a close and then move it to your forum. And before I begin the more formal questions, what I'd like to do is give each of the justices up to 3 minutes to very briefly introduce themselves, but more importantly to focus on introducing their judicial philosophies. And in doing that, what we're going to try to do is start at one end and then just reverse order so that nobody is first or last all of the time. So the first question is, for 3 minutes, is please briefly introduce yourselves and describe your judicial philosophy. And equally important, describe how you do or would implement this philosophy when deciding cases. And please try to do so without the common cliches as, such as the umpire analogy or the I treat each case with an open mind. Try to be as specific as possible to inform our viewers and our audience. Let's begin with Senator Skindell.
Thank you. I am State Senator Mike Skindell. I have been a practicing attorney for 25 years and a state legislator for 10 years, and it gives me some unique experience which I would bring to the Ohio Supreme Court. As we know that a court like a Supreme Court can pull upon the strength of all types of experience. In the United States Supreme Court, of the 111 justices, 40 of them had not served as a trial judge or as a Court of Appeals judge prior to their service on the United States Supreme Court. And we've also had that experience in the Ohio Supreme Court. With regard to generally what I would bring in judicial philosophy to the court, I'm a strong believer in our constitutional democracy and our 3 branches of government. With regard to the judiciary, one of the cornerstones of the judiciary is the doctrine of stare decisis, in which you rely upon past precedents of the court. That doctrine alone gives stability and predictability in our judicial system, and that is something that is essential in implementing our justice system to ensure that the lower courts know how the laws are and what the decisions of the Supreme Court could be, and also gives guidance to those attorneys that advise their clients with regard to legal matters and how they believe the courts will rule in future cases. Also, I believe strongly that in adhering to the 3 branches of government, that the judiciary has a role and responsibility of giving deference to the policies and the statutes enacted by the Ohio General Assembly. It is that body, that branch of government that enacts the policies in this state. Thank you.
And Judge O'Neill, please.
Thank you and good afternoon. My name is Judge Bill O'Neill. I'm retired from the 11th District Court of Appeals, where I served for a decade and some change. I had 2 terms as the presiding judge up there. I have decided over 3,000 cases as a judge. Everything from adoption to zoning, from juvenile shoplifting to aggravated murder. I have sat on the Supreme Court of Ohio by invitation of the late, great Chief Justice Tom Moyer. And more importantly, I have represented clients in multi-million-dollar cases before the Supreme Court, so that my credentials as a former judge and as a lawyer, I don't believe, are open to discussion. There's some really big issues this year in this Supreme Court race. As many of you have heard through the mass media, I'm the judge who refuses to take any money from anybody. I believe that it is fundamentally wrong for a judge to accept contributions from a lawyer or a litigant and then rule on their case. I think it undermines the integrity of the system. I think it tarnishes all who are involved in the process. Recently, I raised my level of discussion a little higher and got specific. In January of this year, First Energy Corporation had, through their subsidiary, Ohio Edison, had a case before the Supreme Court that they argued. 2 weeks later, their political action committee wrote a check for $6,300 to Justice Cupp, $6,300 to Justice O'Donnell, and 4 weeks later, they ruled in their favor. I am not saying that is a crooked decision, but I am saying it is impossible to avoid the appearance of impropriety when you accept money from a litigant and then rule on their case. It's an impossibility. Now, the justices, since I raised that question, have come up with the specter, which I do not believe, that they do not know who gives money to their campaigns. If that is true, they are the first politicians since 1776 who don't know who gave money to their campaign. To clear it up for them, I provided them a spreadsheet this week showing that the First Energy Corporation has given $44,111.12 to the two justices sitting to my left. A week ago, they heard a case involving 300,000 homeowners who are suing First Energy because they think they were cheated. I have said, I do say, and I will continue to say, it is wrong to take $44,000 from a litigant with an active case on your docket and rule on the case. That does not make them bad people. They're very good people. My name is Judge O'Neill. I think we should talk about issues.
And the issue of political funding will be a question that we'll ask later on here. So for Justices Cupp and O'Donnell, there's not necessarily a need to respond to that issue at this time. Said better off just focusing on introducing yourself and your judicial philosophies. Justice Cupp, please.
Thank you. I'm Justice Bob Cupp, and I'm serving my first term on the Ohio Supreme Court. I bring a broad and varied experience to the work of the court, having served as a city prosecutor in Allen County, in the city of Lima, served as an Allen County commissioner, 16 years in the Ohio Senate, including 4 years as the president pro tem, which is the second highest ranking leader in the Senate. 4 years on the Court of Appeals, and as I indicated, now finishing my first term on the Ohio Supreme Court. I think it is really important in terms of when people evaluate candidates for the judge and evaluate judicial decisions to think about the concept that is enshrined in both our national and our state constitution, which is that of the separation of powers. And that's not just a phrase, that is a concept which has real meaning in our constitutional system about the role of a judge in deciding cases. And my view is that while the role of a judge is an important one, it's also a limited one. Judges sit on the bench to decide disputed cases, to protect individual rights and to protect property rights, but they do not sit as a super legislature to rewrite the statute or revise the Constitution through strange or unusual or strained interpretations. We break down the barriers that are separating the different branches of our government and really restrain government from intruding upon individual liberty when judges or the legislature overstep their bounds. The difference between the legislature and the judicial branch, of course, is that under judicial review, the court has the final say on the power. So it's up to an individual judge. While they may have the power to go beyond the authority that's granted to them, to exercise restraint and decide cases simply according to the plain meaning of the statutes and the Constitution. And I think that's what best protects our system of ordered liberty.
And Justice O'Donnell, please.
Thank you very much, Maurice. Good afternoon, ladies and gentlemen. My name is Justice Terrence O'Donnell, and I am very proud to be here this afternoon and participate in what I think is an important forum about the upcoming election on November 6th. I'm particularly proud to be an elected member of the Ohio Supreme Court, and as I am here this afternoon, I'm serving in my 10th year as a member of the Ohio Supreme Court. My judicial career began as a law clerk in 1971 when I had the privilege of clerking for then Justice J.J.P. Corrigan while he was a member of the Ohio Supreme Court. I followed that clerkship by having the privilege of serving for Judge John V. Corrigan of the 8th District Court of Appeals and also for Judge John Manos, who later was appointed to the United States District Court and served there. My early training then was under the tutelage of jurists, each of whom was widely respected in the state of Ohio. That developed for me a judicial philosophy and helped formulate in my mind the manner in which judges conduct their affairs and the manner by which they decide cases. I was privileged to have been elected to the Common Pleas Court in Cuyahoga County, and I served there for a period of 14 years, virtually trying every type of case in Cuyahoga County, which is the busiest trial court in the state of Ohio. I followed that 14-year period by serving on the 8th District Court of Appeals in Cuyahoga County, and I had the privilege of serving there for 8 additional years. And following that service then, I have been a member of the Supreme Court since 2003, and I bring to this office a period of 32 years of judicial experience. It's my view that as a cornerstone of judicial decision-making, we look to the doctrine of separation of powers. And that means that the legislative branch of government is the lawmaking branch, that the executive department is the department that enforces law, and the judicial role is to interpret laws and apply the law to a given set of facts. In every instance, judges must be open-minded, fair, willing to look at all sides of every issue, and approach the case with no preconceived ideas about outcomes. It is this philosophy, nothing new to me, something that I have developed through the tutelage of the jurists that I have alluded to and practiced in a 32-year judicial career. When we make decisions based on the law that is predictable to individuals and in accordance with law, by so much do we instill public confidence in the decisions rendered by our courts. Thank you very much.
The next question is a quick one that might be kind of fun and I think will be helpful to our audience. The justices of the United States Supreme Court operate at such a high-profile level that most lawyers can at least identify on a map their judicial philosophies. However, we think that Ohio Supreme Court justices on this issue often fly too far under the radar. So to help us get a better feel for your judicial philosophies, if you kind of, I think what would be helpful is if you pick a member of the United States Supreme Court who best typifies your particular judicial philosophy. Maybe there isn't one, or maybe there are several, but if you could pick just one, that would be great, and explain why that particular member of the United States Supreme Court best reflects your philosophy. Justice O'Donnell.
Well, thank you. This is an interesting question, and it's one that I've spent some time looking at. Because while it may be clear to you, Maurice, or some of you in the audience, it isn't clear to me exactly what the philosophy is of the 9 members of the United States Supreme Court. I guess I thought I knew what Justice Roberts' views were, but recently I've come to reconsider exactly where his views are, especially on the Commerce Clause as it relates to the United States Constitution. But it's a great question because it gave me a moment to reflect. I appreciate the fact that Justice Anthony Kennedy is the swing vote on the court and is widely viewed as such. But his views, as I'm given to understand, fall from a moral perspective, and he is more of a moralist on the court. And then I found it so interesting that Elena Kagan, while predicted to be ruling in a certain fashion, has not yet come to that. And I studied Stephen Breyer, who is a pragmatist on the court. And then, of course, I began to read about what's been written on Antonin Scalia's philosophy as a textualist or as an originalist in terms of constitutional application, and come to find out that scholars would say that Clarence Thomas is far more conservative than is Antonin Scalia. And without going into the rest of it, I began to look at decisions that I have written and participated in to try to develop exactly where I was. And I guess I can tell you that in certain instances I think Scalia is correct, in others I think Kennedy might be correct, and in still others I think Justice Roberts also exhibits the kind of case decision making that is in accord with my thinking. So I'm unable to tell you that one or another of the members of the court are exactly the profile that you might find in my case decision making. It's best described by my view to approach each case with an open mind, consider what the facts and the law are, and reason to a conclusion.
And Justice Cupp, you got a helping hand from Justice O'Donnell, who laid out many judicial philosophies and many of the justices. So,
well, I won't repeat those. I'll just concur in those remarks. And I think it's a little bit inaccurate to be able to adopt a justice and say that's the one that we mostly agree with, because it's true. There's always some things that we might think that we would decide differently. Of course, we don't have the record, we don't have the oral arguments in those cases. But I think it's also a little bit dangerous to pick a current member of the court, because they come with the sort of the current issues, and it's sort of emotionally laden, and depending on what side you are. So I'd like to just step back a little bit and say that probably a former justice that I agree a great deal with was now the late Chief Justice William Rehnquist, who actually, by the way, came to Ohio and helped to dedicate the Ohio Judicial Center when it first opened. And the reason that I mentioned William Rehnquist is that he was really a model of judicial restraint. As a Chief Justice, he had power to essentially reinterpret the Constitution and the laws, but he didn't believe that he had the authority to do that, and instead deferred often to the legislative branch of government and to a precedent that was decided, rather than trying to write his own preferences into the law. He also sought to enforce the constitutional restraints on Congress's commerce power, and we know that very often Congress tries to get into local communities and regulate what local communities and states do, and he helped to preserve state prerogatives. And maybe even just as important is that even the all the philosophical, regardless of the philosophical view of the other members of the court, they held him in high regard, because he had real warm and cordial relations with all of the members of the court. And I think that's really an important aspect of being a jurist as well.
thank you. And Judge O'Neill, same question to you.
I'm glad it happened early in the event. Justice Cupp and I are in agreement. The day that Justice Rehnquist came to open the Ohio Supreme Court, I was there in my robes, and I don't think I've ever been more proud to be a jurist in Ohio, to have the Chief Justice of the United States Supreme Court opening our new home. Following Justice O'Donnell's analysis, I guess off the court right now, I've always been a big fan of Sandra Day O'Connor, and the reason being that she was so unpredictable. You could not figure out which way she was going to go, and she was always the swing vote. And I think that's the mark of a good jurist, that you're unpredictable and you don't know what to do. I will come out strongly on one justice, and that would be Justice Scalia. We don't agree. He seems to be a very well-educated, bright person. But I have a problem with any justice that I believe to be outcome-oriented. I'm reminded when I was first a judge on the Court of Appeals and I was doing I thought, a workmanlike project on a search case for a school locker, and I wrote, you know, I'm a former journalist, and I wrote that it is improper to talk about the grandeur of the United States Constitution in the morning and violate its basic tenets in the afternoon, when they say that, you know, kids have no constitutional rights to privacy. And my law clerks were all with me until they came across a Scalia opinion, which was the student-athlete search case. You might remember the United States Supreme Court said, well, if you're a student-athlete, we'll search you whenever we want to without probable cause at random. And I thought that was wrong. And when you gave me this question, I like it. I'm a scholar. I like doing research. And last night I went back and I wanted to see what Scalia said. And I want to share it with the world because I was so enraged 12 years ago. I'm gonna say it again. Is it time?
Yeah, it's time. So if you could go quickly.
I'll do quickly. Legitimate privacy expectations are even less with regard to student athletes. School sports are not for the bashful. They require suiting up before each practice or event and showering and changing afterwards. That was how Justice Scalia justified an unreasonable search. I don't like him.
Thank you. And Senator Skindell, please, same question.
Thank you. The question did not require us to pull upon current Supreme Court justices. So I'll go into history a little bit. And one of the justices that I would like to emulate is a former United States Supreme Court justice who was also the former governor of the state of Ohio, Salmon Chase. Governor Chase, Justice Chase, what he is not really, the average person does not know about him, but he was the individual that played a key role in the preservation of our union with respect to funding our efforts in the North, our troops, and working as the Secretary of Treasury under Abraham Lincoln and being a member of the team of rivals. But on the United States Supreme Court, what Salmon Chase did was gave excellent legal analysis that formed how we interpret and apply the 14th Amendment of the United States Constitution. In addition, what was best known of Salmon Chase was his fairness on the court. He was the justice presiding over the impeachment trial of Andrew Johnson. And despite the political pressures on all sides, Salmon Chase was known of having an even and fair hand in that impeachment trial. And that's what I want to be known for as a Supreme Court justice here in Ohio. One other person that I would call upon, a little bit more recent, would be Justice Stephen Breyer. And what I liked about Justice Stephen Breyer is not so much, I'm not calling upon in raising his name the outcomes of decisions, but how he has applied the facts in particular decisions. His decisions, his opinions have been fact-laden, and that is highly important to give guidance to lower courts and guidance to our attorneys in applying the law.
Thank you. And on to the next question, which will start with Senator Skindell. We'll stay right there. And this is a question from the true law jocks in the room to each of you, the justices. And an important question for everybody, though, nonetheless. Discretionary review of the Ohio Supreme Court permits the court to review cases of, quote, great public interest or great public importance, or cases that raise, quote, substantial constitutional questions. This standard offers wide latitude. So what we'd like to know is, how does your judicial philosophy influence the kinds of cases that you are or will be looking for as a member of the Ohio Supreme Court? And both the type of cases and also the number of cases. Should the court hear as many cases as possible, or as few cases as possible, or is the number just right? State Senator Skindell.
Thank you. One of the reasons why I ran and am running for the Ohio Supreme Court is to bring balance and fairness into the court. And one of the components is those cases that the court takes up in discretionary review. what we have seen in recent years in the court is that certain types of cases impacting certain type of litigants have been predominant in the Supreme Court's acceptance of these particular cases. And that's a great concern because it shows and it's reflective that having, for the most part, a predominant philosophy, as Justice O'Donnell had talked about, being on the court, it's an injustice to all Ohioans because not all viewpoints are represented on the Supreme Court. As we know that there's no elected Democrats currently on the Ohio Supreme Court. There's one Democrat, but no elected Democrat. What we need is to ensure that our court represents all Ohioans and reflect all viewpoints, because when we decide what cases to take and how we're going to decide those cases, we need to pull upon and build strong legal doctrine. And you can only do that if you are around that conference table discussing all viewpoints as represented by all Ohioans.
And Judge O'Neill.
If there's one thing I learned on the Court of Appeals, no matter how trivial a case looks to you or me or the lawyers, to the person who filed the lawsuit, it's doggone important, and it is their day in court. The problem we have at the Supreme Court level is the volume. The reality is that once a matter of law has been settled, it should be left alone. I don't believe that every case needs to go to the Supreme Court. I don't intend to be a bleeding heart that's saying, okay, we've got to bring the Smith case in so they can see finality. The reality is most finality happens at the trial court level. Courts of appeals maybe reverse 5% of what they see, and the Supreme Court, I believe, should be the ultimate arbiter of big issues. The reason I say that is that, as some of you know, the last time I ran for Supreme Court, we had some federal court involvement on my ability to speak on issues. At that time I did say, and at this time I do say, the Supreme Court of Ohio was and is wrong on school funding in Ohio. I may have been, clairvoyant at that time because, as you see, the educational system in Ohio is imploding before us. It is being purchased one building at a time by the highest bidder, and the Supreme Court of Ohio, when they were given the opportunity to make the big call in the separation between the legislature and the judiciary, they blew it. And then they kicked it back to the legislature, and every taxpayer in Ohio is now paying the price. So I believe that when we talk about discretion, I am not unhappy with the Ohio Supreme Court. I think they do a good job. But every once in a while they just drop the ball because they're trying to increase volume by putting their imprimatur on cases which are already settled. You see so many cases come before the Supreme Court that everybody knows what the outcome is going to be, and that's the way it should be. And I say those cases should not have been accepted, and the Supreme Court should use its time on the big issues and do it right.
Thank you. And Justice Cupp, same question to you, please.
Thank you. Talk about how I look at cases. And when I look for cases to accept under our discretionary review, and I might add that the discretionary review is a smaller number of cases than most people might think. There's a lot of cases that come in under original jurisdiction. But I look for cases where the law is unsettled in the area. And so this will help create some clarity to the law that, of course, must be applied by all 720 plus judges in the state and the 385 trial and appellate courts. Or where the law, maybe the statement is correct, but the law is being misapplied to the facts in cases. And of course that is almost the same as the incorrect law. And the other thing that I look for is where there are conflicting decisions among different courts. And it might not be a conflict that under the Constitution has to be certified and come to us, but one in which courts are deciding the same case different ways. That means the law is not being applied uniformly throughout the state of Ohio, and so those cases need to be brought in so they can be settled as well. I do not look for cases on the basis of any policy or ideology. Rather, all of the cases that fit the criteria need to be brought in to the court for a determination. The one thing that might rule out some cases is they come to us in a very unusual procedural posture, or they're very fact-specific. And so it's hard to get at the real issue involved, and those cases really are not appropriate candidates for the court to take in, because we're not going to be able to develop any clarity in the law in that regard. So that is how I look at cases. If we have a large volume of cases that need to be brought in and decided, I think that's what we should do. If it's a smaller number of cases, then that's what we should do, the cases that fit this criteria. Thank you.
Thank you. And same question to you, Justice O'Donnell.
If I understand the question, it's with respect to the ideology of the court in exercising its discretionary review for cases to be considered by the court. In almost 10 years on the Supreme Court, I've probably cast some 25,000 votes on different cases in this realm. The process that is undertaken at the Supreme Court in exercising our discretion is that each member of the court individually reviews every memorandum in support of jurisdiction and every memorandum opposing jurisdiction. And that work is done individually. And then when we meet in conference, we discuss the matters in order to determine, as the Constitution says, whether the case has a matter of public or great general interest. Now, any judge who has an agenda, that is, someone who is trying to change law, should not be exercising that kind of control in order to change a field of law. Judges are not enactors of state policy. That role belongs to the General Assembly. What judges do is to determine whether the case presented has or doesn't have a matter of public or great general interest that is not well understood by the lawyers or is being applied differently by separate appellate districts around our state. So when I exercise this type of authority in determining whether or not a case should or shouldn't be presented, I am looking for matters that apply broadly to 11.5 million people in our state, and that will bind all of the 730 judges throughout our state, and that will clarify the law in a field where the lawyers need some direction. And that is the basis on which this exercise of authority is cast in my case. Thank you.
Thank you. And we'll stay right there with Justice O'Donnell. Will be first for this next question. And this question is one kind of steeped in legal philosophy that I think that some of you in the room and perhaps even Justice Cupp will recognize as perhaps a pet issue of mine, but one that I think plays an important role in how justices approach cases. And let me take a moment to set it up because of that. The preamble to the Ohio Constitution references its purpose as securing the blessings of freedom. And the very first section of the Ohio Constitution, Article 1, Section 1, states or references the inalienable rights of enjoying and defending liberty, life and liberty, acquiring, possessing, and protecting property. Given this, what level of deference should be owed to policies and actions undertaken by the Ohio General Assembly and also local subdivisions, and why? Specifically, do you believe that a rational basis review is an appropriate level of scrutiny when government action transgresses perhaps some form of liberty or another? Similarly, the court often begins its inquiry with a presumption that the government conduct is constitutional and puts the burden on the citizen to prove their case beyond a reasonable doubt. Now, this presumption arguably comes from a number of different sources, most prominently that the legislature has actually carefully considered the constitutionality of what they enact before they enact it. So is this level of deference to the legislature appropriate, or in the alternative, should courts sometimes begin with the presumption that citizens should be free? So should the court presume liberty or presume constitutionality? One and two conflict.
That's all there is to that question?
And you've forgotten it by now.
glad you did provide the questions to us in advance. When we approach a constitutional issue, or when I approach the examination of a constitutional issue, I presume a statute to be constitutional, because this is a statutory framework within which we begin an analysis. It's not routine, and each case is given individual consideration. But we begin with a presumption of the constitutionality of enacted ordinances. And then when conflict arises, either with respect to the application of a due process claim, for example, there needs to be some basis by which courts can provide some rationale in order to reach a conclusion. And there are various tests that have been applied, but the rational basis test, that is there any rational basis for the exercise of authority by the local ordinance or by the General Assembly or whatever authority, legislative authority is involved, exists for that determination. And while this may seem to be something that our forefathers or our founding fathers have considered, the application of these principles are alive in cases that we review on a regular basis. And there are innumerable challenges to local ordinances and to state statutes involving these questions. And I have consistently applied a rational basis when it's appropriate with the presumption of constitutionality. I think it's instructive, because when these kinds of cases arise, the lawyers need to know where the court has been and what conduct would be appropriate, and then when there are differences, what arguments might be persuasive with the court. And so the court can lend a degree of predictability and certainty to the law so that lawyers will know how to advise their clients and clients will know how to conduct their affairs.
Thank you. And same question to you, Justice Cupp.
Well, Mr. Thompson, as you are well aware, there is a presumption of constitutionality, and to establish that the conduct of the law is unconstitutional has to be done beyond a reasonable doubt. And that is the standard that the court has followed for many years. I'm not sure what its origin is. And the party that is seeking to approve a case always has the burden in that regard. As I suspect that one of these days we may receive a case in which you are the attorney on involving this very issue, I'm not sure that it would be wise for me to make a comment on whether or not it is appropriate that we do what we do, other than we do it. And if it is to be changed, obviously someone needs to bring a case, because the courts are reactive institutions. We don't reach out and grab an issue. Somebody has to bring it to us and litigate it. The briefs filed on both sides that lay out the legal arguments, the reasons for the standard, the reasons against the standard, the oral arguments on it, in which the justices will be able to ask questions of the attorneys if there's something we don't understand, or to help understand the extent of what the change might be, and then we would make a determination. And so that, I think, is about all that I can say on this issue without transgressing where I should not go in the event that this case does come before us.
Thank you. And the same question to you, Judge O'Neill.
As the United States Supreme Court said in Minnesota versus White, there are no issues that won't come before the Ohio Supreme Court. And so, you know, for us to remain silent on all issues deprives the voters of knowing where we stand. Specifically, you want to know what level of deference should be owed to the policies and actions undertaken by the Ohio General Assembly. And I suggest to you that when the Ohio General Assembly oversteps the Ohio Constitution, they are entitled to no deference, none whatsoever. I think we have a problem in Ohio in the separation of powers. I believe the Ohio Supreme Court is a separate and equal branch of government. And I guess I get back to where I'm talking about. Yes, I will, and yes, I do talk about school funding in Ohio, because it would be foolish of me to run for the Ohio Supreme Court and not talk about the job that the Ohio Supreme Court has done in the past. If they have failed, they need to correct it. And the reality is the Ohio General Assembly has been found to be in violation of the Ohio Constitution, and the Ohio Supreme Court has done nothing to correct that situation. That is wrong. And the other part of your question is, what level do we give them? Yes, I agree with Justice O'Donnell. There is a presumption of regularity and a presumption of constitutionality of anything that's passed by the Ohio General Assembly. But once we get past that level, the Ohio Supreme Court has an obligation to the 11 million people in Ohio to do their job. That's to enforce the Ohio Constitution. There is a provision in the Ohio Constitution that there shall be a thorough and efficient method of educating children in Ohio. We do not have that in Ohio. The reason I know that is the Ohio Supreme Court told me we don't have that. But they issued an order without a remedy, and an order without a remedy is a disgrace.
Thank you. And to you, State Senator Skindell, same question.
Thank you. Mr. Thompson, I must commend you and your organization on such a thoughtful question, and it poses a lot of scholarly debate, it's very intriguing. It calls to mind the story that when the drafters of the United States Constitution finally reached an agreement as to what the language to the Constitution would be, and the drafters were leaving the hall, Dr. Franklin walked out, and the wife of the mayor of Philadelphia walked up to him and said, "Dr. Franklin, what have you given us?" And Dr. Franklin replied, "Liberty, if you can keep it." And your question goes directly, for example, to economic liberty. And let me give you an example. If a legislative body adopts legislation that says only licensed morticians can sell a casket, is that constitutional? We give, as Justice O'Donnell and Justice Cupp and Judge O'Neill has stated, a presumption to that legislative enactment, despite the fact that our common sense today know that there's no reason why somebody else cannot sell a casket to somebody else other than a licensed mortician. But we in our law and our legal system, we do not demand from government to make a case as to why that particular law that is taking liberty away from some business, we place no burden on government to say that law is rational and why does that go to health and safety. But instead we place it upon the litigant and we give this high burden to overcome. And your question poses some debate. The unfortunate part is we do have stare decisis. We have to apply that presumption. We have to apply the burden of proof and how we look at these. But your question poses great debate in our law schools.
Thank you. And staying right here with Senator Skindell, I'm going to jump ahead in your list a little bit to a question because an issue posed by Judge O'Neill at the outset is referenced here. So I want to make sure we get this question in. So the question is about the influence of campaign funding. Do you believe it is important to reduce the influence of campaign funding in judicial elections? Or do you believe that such funding even has influence? And I would like to contrast this. One thing that I noticed in perusing the candidates' homepages is an organization doesn't just give money, it can also endorse candidates. So there are all kinds of different free speech activities organizations can and do partake in. And is it really fair to draw a line between contributions, say, or endorsements, or other kinds of support, which people no doubt have a right to give to candidates whom they believe in? So ultimately, though, is it important to reduce the influence of campaign funding? Does it have an influence? State Senator Skindell.
I think by human nature, campaign financing, when you have folks contribute to judicial campaigns, you're undermining the goal of being fair and impartial at all times. It does have a role. It's part of that human nature. We as candidates pledge to try to pull ourselves away from that, and and try to be, when we actually become justices or judges, to be fair and impartial when those cases come before us. My belief is, here in Ohio, we have a system that is a system that, to a certain degree, is made for failure. We try to promote fair and impartial judicial races, but we have our candidates run in partisan primaries, and then when we get to the general election, there's no DNR next to you. We put financing, private financing into these campaigns. There's limited regulation. What I support, I believe that we should try to get a cleaner system. If you're going to have partisan primaries, the general elections should be partisan. If you want to remove it out of the system, remove it totally out of the system. With regard to actually campaign contributions, I have advocated for public financing of judicial races similar to that in the state of Arizona. It has had great success in trying to remove the influences of money in these elections, and I strongly believe that the state of Ohio should examine that model.
Thank you. And Judge O'Neill, same question to you.
I think it is imperative we all, judges, politicians, and citizens, take a look at this and understand the corrosive effect that we've been experiencing in Ohio since 2000. These judicial races for Supreme Court of Ohio are topping out at $1 million now. That's what it takes to run a good TV campaign. You know, I ran for Congress 2 years ago, so I know TV and I know fundraising. In the judiciary, it's different. Judges should not be taking money, and I guess I look back at the thought that every journey must start with a single step. I think as a matter of an imperative, there should be a prohibition in Ohio that anyone who has an active matter in front of a judge is prohibited from giving any money to that judge. And as Senator Skindell said a while back in the Plain Dealer, refuse or recuse is the rule that should be applied. If you have an active member on your docket or a matter on your docket, you just don't take money from those people. But I can take it up a level. 6 years ago I proposed, and I still propose. Put $10 on the court costs of all the people who are clogging our dockets right now. Every lawsuit in Ohio, put a $10 court cost on that lawsuit, create a judicial education fund, and in that fund, then judges would be paid to get their message out to the people, but by taking that public funding, they would be prohibited from taking money from anyone. It is a system that is crying out for an answer. The answer is money and judges don't mix. They never have and they never will.
Let me ask a follow-up question on this point, because I did mention the issue of endorsements, and I want to know, just if you could in 30 seconds, Judge O'Neill or Senator Skindell, maybe 30 seconds to a minute, where do you draw the line? So if you say campaign funding, that kind of support is not okay, but endorsements are still okay. It seems like you're on a slippery slope to the point where you put a gag order on people who want to support candidates who also have important issues that may end up before the court. So how do you draw that line in a non-arbitrary fashion? Why choose money and not other forms of support?
Well, because this is America, and we have freedom of speech. And the problem that I see is as we're trying to limit speech. For example, the United States Supreme Court has said money is speech, therefore cannot be limited. Well, then why is it limited? Why can people only give me $3,500? Why couldn't they write a check for $35 million? The problem is money is not speech, but you can't start limiting what people can say. I'm endorsed, freely admitted, by 1 million labor people in Ohio. Endorsed. They like my candidacy and they like my message. Certainly I would not be advocating that I can't rule on any cases that involve organized labor or injured workers. But it's a fine line, and that's why I say every journey starts with a single step, and I say the single step is, if you're in front of me, you can't contribute to me.
Okay, thank you for that. And back to onto, with those issues crystallized onto Justice Cupp.
Crystallized? Do you think they're crystallized?
No, I think they're actually gotten a little fuzzy. So let's try to clarify things a little bit. We have a system in Ohio, under the Ohio Constitution, that we elect our judges. And when you elect judges, that means that the candidates have to be able to inform the voters, because as we already mentioned, judicial races are very much under the radar, and people don't know who the candidates are, and they don't know how to evaluate candidates for judges. So you run a campaign, and part of the campaign is providing information to voters so that they can make that decision. Unfortunately, I've not found any TV or radio outlets or newspapers in this state who are willing to run advertisements for candidates without charging them. So in order to be effective, you have to have money that goes in there. Now, we have very strict limits on what judicial candidates can do in Ohio. First of all, the candidate themselves cannot ask anybody individually for money. They cannot accept money from any person. You have to have a separate campaign committee with a separate finance director that is, so it builds a little wall between the judicial candidate and the campaign. And there's only fundraising is only allowed 1 year out of 6 in the year in which the judge is elected. So this is a balance that has been created to be able to have informative campaigns, and yet they have some restrictions on the role of money in the campaigns. And I think that's an important distinction that we have to have. Unless you're a candidate that has lots of personal wealth, you simply cannot run a statewide campaign and inform voters without some type of support. The rules of judicial conduct provide that when contributions are within the limits that are established, that those do not create any impropriety in reality or in appearance. And what really boils down to is that we must ensure that the people that we elect have character and integrity and a commitment to applying the rule of the law, and the law decides the outcome of the case, and the chips fall where they may. And so that is why it is very important for voters to carefully evaluate the candidates and their backgrounds and reputations and beliefs.
Thank you. And Justice O'Donnell, same question to you.
Thank you. Ohioans have rejected the notion to change the fact of electing judges in Ohio. It was posed to the electorate as a constitutional amendment, and it was resoundingly defeated. The public has control over the elected members of the judiciary in the state of Ohio, and the public adheres and seeks that public accountability in the course of our elections. Given that, the responsibility to provide regulations for the conduct of judicial campaigns in Ohio rests with the Ohio Supreme Court. We're aware of the continuing perception that there may be an influence of campaign contributions in judicial campaigns. I can tell you there is no cause and effect relationship existing, as Judge O'Neill would have you think, between a campaign contribution and a case result. There's no evidence of that anywhere. The fact is that judges are not permitted to accept contributions in Ohio because we regulate that by having them develop a campaign committee for the purpose of raising funds. And those committees are charged with collecting the money, reporting the money for full transparency. This is the way it's been done in Ohio. It's the way it's been done by all 730 judges and candidates throughout our state for a decade. We regulate the minimum and the maximum amounts of contribution that can be made, and those numbers vary for trial courts, intermediate appellate courts, and state Supreme Courts. Furthermore, we review this matter at the Supreme Court on a regular basis. And it's interesting and I think instructive for all to know that the Code of Judicial Conduct permits judges to accept contributions to campaigns in accordance with those limited regulations and conduct their dockets. And the comment to Rule 2.11 regulating those conducts says this: a judge's knowledge that a lawyer, a law firm, or a litigant in a proceeding that contributed to the judge's campaign within the limits set forth in the rules, or publicly supported the judge, does not, in and of itself, disqualify that judge. Now that's the regulation that we have in Ohio. It's been there for a very long time. And when our court adopted it, we put it out for public comment. There was no comment from Mr. O'Neill at that time about it. He didn't participate in the committee, didn't have any comment. It's only when he gets a personal gain by making a public statement just before an election that we hear this. The other thing is, I would ask Mr. O'Neill to regulate the fact and admit to the public that the allegations that he raised earlier in describing his background, which challenged Justice Cupp and my receipt of a contribution from First Energy, was the subject of a grievance that he filed. And he hasn't had the integrity to tell you that grievance was determined by a panel of 3 judges to be no conduct violating the Code of Judicial Conduct, and that no good cause is found for investigation of grievances to exist. And he hasn't had the integrity to tell you his complaint was dismissed, and these charges are false.
Thank you for that.
Sure.
We have
I must respond.
Judge O'Neill, take a moment to respond since your name was mentioned in Justice O'Donnell's remarks. Just a moment, please. Then we have to move on.
Yes, it's the old integrity question. The reality is that disciplinary proceedings in Ohio are confidential. The only person that is permitted to disclose the outcome of a disciplinary complaint is the person against whom it was made. Without hearing. The Supreme Court's disciplinary arm said there is no appearance of impropriety if you take a $6,300 contribution from a litigant 2 weeks after oral argument. No appearance of impropriety without a hearing. It is the other problem that Justice O'Donnell raises. These committees are frauds. Let's be grown-ups about this. A judge puts together a committee, the committee holds a cocktail party, and the judge goes to the party to thank the people who were there. That's fraudulent conduct. It is the emperor has no clothes.
That's 1 minute, and Justice O'Donnell's name was mentioned. I don't know if you want to respond to that, or we can move on to the next question otherwise. The next question is for you anyway.
Mr. O'Neill is not my opponent. Perhaps Justice Cupp should have an opportunity to.
We're so used to being opponents.
I will tell you, however, that Mr. O'Neill had no problem blast faxing the media in Ohio when he filed the complaint, even though he now admits publicly that he knew it was a violation. The sad part is he has not the integrity to tell you until it's brought to him that it had been dismissed more than 2 weeks ago.
We are going to move on. We're going to keep the microphone right there with Justice O'Donnell. This is the one audience. We have time for one audience question, and then we will move to closing remarks. This is an anonymous question, and I have a similar question like this, so I'm going to ask both together, because I believe this is what the questioner is getting at. The question is, should judge-made law, such as presuming legislative acts to be constitutional, undercut enforcement of the Constitution's provisions? If so, why? If not, why not? Now, I believe we already had a discussion of the presumption of constitutionality, so I would like to piggyback on this with a question which you were provided. And that question, which I believe the questioner is getting at, reads like this. Where you believe there is a conflict between original meaning of the Constitution and existing precedent, so if there is a conflict and you believe there is a conflict, which of these two controls your decision? Justice O'Donnell.
The question suggests that there are absolutes between precedent by court decision and presumption of constitutionality. Every judge in Ohio takes an oath to support the Constitution and the laws of the state of Ohio. So the question becomes, when is it that a court should move away from its established precedent and/or apply a constitutional provision? It's my view that the Constitution is an immutable document. It does not change. And the highest role of a jurist is to interpret the Constitution. The best example I can give you to highlight the viewpoint of when you reach this crossroads would be the case of Plessy versus Ferguson, which announced separate but equal connection with racial discrimination. But then came Brown versus Board of Education later on. And the Supreme Court was faced with either adhering to its earlier separate but equal doctrine or changing that law. And the United States Supreme Court moved into a new era, set aside the Plessy decision, and based on changes that had occurred, adopted Brown versus Board. I believe that is a fair and rational application and expresses the kind of judicial discretion and decision-making that I would exhibit if I had the question presented. Thank you.
Thank you, Justice O'Donnell. And same question to you, Justice Cupp. If there were to be a conflict between precedent and original meaning.
Sure. Let me say, first of all, that I think stare decisis is a binding principle when it comes to interpretation of common law or statutory law. That creates some stability and consistency in the law, and clarity in the law, and predictability in the law. When it comes to constitutional law, I think we have a little different situation, because obviously the text of the Constitution is the most important part of it. And so on constitutional law, stare decisis, or following precedent, is a guiding principle. I don't think we want to throw that out entirely, because we don't want our constitutional interpretation to sort of flip-flop back and forth when you introduce uncertainty and instability in our constitutional law. However, the language of the Constitution would control, and of course it would involve a lot of involving arguments on both sides in reaching that decision.
Thank you. Same question to you, Judge O'Neill.
I'm glad we're ending the session with my having the opportunity to say that I agree with my friend, Justice O'Donnell. He's absolutely right that Plessy versus Ferguson, the trilogy going from Plessy to Brown versus Board of Education, clearly showed the role of a Supreme Court is not to write law, but to interpret law. And that also gets us back to our first question about which justice do we like. And when I was doing my research last night, the other one that came to my mind is the classic confrontation of the Constitution in the Affordable Care Act at the national level, when Chief Justice Roberts said, "It is not our job to evaluate the wisdom of the legislature. It is our job to evaluate the constitutionality of what they do." So there's no question that precedent is what guides the Supreme Court.
Thank you. And same question to you, Senator Skindell. It is precedent versus original meaning.
Thank you. The concern that this question raises is that just because a political makeup of a court changes, then you can change a decision with regard to the application of the Constitution. So if the political makeup of the Supreme Court occurs and there are a number of folks to reverse the recent health care decision, does that make the recent health care decision now unconstitutional if you just have a change in makeup and they decide to take a case? It poses a problem when you don't adhere to precedent and you instill that type of instability and unpredictability just because the court's political makeup changes. That's why the doctrine of stare decisis is important. It doesn't mean that in all instances do you adhere when you firmly believe that a past precedent should not be applied in the current setting. But if you break from that precedent, the court has to be clear and precise as to why they're breaking from that precedent, not just because they themselves felt that the original decision was wrong. That's not sufficient. You need to really spell it out so that there's predictability and stability in the court system, which makes up that three branches of government and keeps our constitutional democracy whole.
Thank you. And now to the final question of our forum. And it allows you some leeway to fashion your closing remarks however you'd like in about 2 minutes. But I do want to posture it through a question. And as an introductory story to this question, a few years ago, I had the opportunity to vet a candidate for statewide office. And I will never forget this experience where this candidate was running as the anti-so-and-so candidate. And I asked him the question, why do you want to hold this office? And to my surprise, there was simply silence on the other end. So we don't, in other words, what we look for is people who have something they want to do with the office, not just to be in the office, to be in the office. So my question to you, and if you could typify your closing remarks by touching upon it, is what above all else has caused you to run for this office? So what is it you're trying to accomplish by being an Ohio Supreme Court Justice? Senator Skindell.
Thank you. Growing up in my family and sitting at the birthday dinners or the holiday dinners, we would always have discussions about politics or policy that was making the news that day. And my uncle, I remember, always took the devil's advocate. So if you stated a position, he would state the opposing side. And that taught me that it is very important when you have a body like the Supreme Court setting legal precedent and legal doctrine to ensure that you have multiple views being presented. And the failure in the court today is that one philosophy, for the most part, is brought to the court, and not all philosophies are brought to the court. And when you do that and have that scenario, you have an injustice to all Ohioans that there's not a complete discussion. And therefore, when you only have one side looking at a position and one philosophy looking at a position, there's not a sound discussion in developing the final result in that particular case. I am running for the Ohio Supreme Court to bring fairness and balance in the court. Not only the types, in deciding the types of discretionary cases the court takes, but in the ultimate decision. But I pledge so in a way to try to ensure that around that conference table or on the bench that there is an alternative view being presented and open for discussion, and that all justices try to come together to reach a decision. Thank you.
Thank you, Senator Skindell. And Judge O'Neill.
It's a great question. We get it all the time on the campaign trail. We particularly get it in the editorial boards of the series that we're in right now. The reality is, I guess I've been described as a Renaissance man by many people. I'm a retired Lieutenant Colonel, United States Army. I'm the father of an Iraq War veteran. I'm a registered nurse who works in a pediatric emergency department. I've been a Court of Appeals judge for a decade. I've been an Assistant Attorney General for another decade. I've been a small-town lawyer. I'm running for the Supreme Court because one is, this is round 3 with Justice O'Donnell, and thank God it's the last time we're going to see each other on the campaign trail, because we're friends, and one of us will win and one of us will lose, with Justice Cupp, of course. I'm running for the Supreme Court because I want to return the Supreme Court to the non-contributors. The Supreme Court seats in Ohio have become purchases. It started in 2000, and it's gone on for the last 12 years. It has to stop. I am the person that can stop it. I am an experienced judge. I'm an experienced lawyer. I am 65 years old. I don't need this job. I want this job. I'm going to be a justice on the Ohio Supreme Court if the people of Ohio agree with me that money and judges don't mix. because if they agree with me, we will take this single step in a long journey in changing the way we elect judges in Ohio. Thank you.
Thank you, Judge O'Neill, and the same to you, Justice Cupp.
Thank you. I'm running for re-election to help ensure and maintain the system of justice for Ohio that is stable, consistent, predictable, and fair. One in which the rule of law is applied to the decision in cases, and one in which the role of the court is to interpret and apply the law according to its plain meaning, not to rewrite the statutes or remake the Constitution from strange and unusual interpretations. And I think I'm fairly uniquely qualified to do that, having been elected to serve in all three branches of our government, the executive branch as a county commissioner, wrestling with the local issues and concerns that we have to deal with on the local level. And local cases do get to the Ohio Supreme Court for resolution. Having served in the Ohio legislature for 16 years, helping to write the law and the statutes and create the policies that we live under, and now having served in the judiciary for almost 10 years, applying and deciding the law to the facts that come before us in cases. Having served in each branch of government, I am able to distinguish the role of each branch and the strength and weakness of each institution. And I think that's an important insight when it comes to how a judge approaches a case in deciding it. We have to remember, as George Washington said, that the administration of justice, which is what courts do when they decide cases according to the rule of law, is the firmest pillar of our government. And I think that preserving our ordered system of liberty is something that's so important to all of us, and it's something important for me that I'm fully engaged in. And that's why I'm serving as a justice of the Supreme Court and running for re-election.
Thank you, Justice Cupp. And finally, the same question to you, Justice O'Donnell.
Thank you. I have built a 32-year judicial career. I've dedicated my life to the state judiciary. My father was a Cleveland policeman, and he served for 33 years, so public service is not something that's new to my family. I believe that the constitutional rights given to us by our forefathers are a cornerstone for the lives of all Ohioans. And it is the judiciary that is the party that stands between abuse of those rights and the rights that we all enjoy to guarantee our freedom, our liberty, and the free exercise of our rights in our society. It is the role of the Ohio Supreme Court to dictate to the other jurists in our state confused and disputed issues of law, and to write rules of law emanating from cases that are clear and will be followed by those inferior tribunals. I respect the separation of powers, the right of the legislature to be the policy-making branch, and that jurists should not legislate from the bench. They should simply be the interpretive branch of government. When we do this, we instill public confidence in the decisions of the Supreme Court, and that is the basis of what we've done. I've been privileged to also implement a mentoring program in our state for new lawyers so that they can get connected with other lawyers in the state and learn the right way to conduct the affairs in the legal profession. This has been a model program for the United States and is copied around the country. I'm running for re-election to continue to maintain high standards of integrity, to instill public confidence, and to promote professionalism in the state of Ohio. I respectfully would ask for your consideration on November 6th.
Thank you, Justice O'Donnell, and thank you all for your excellent participation in today's forum. On my own behalf and on behalf of the Federalist Society and the 1851 Center, we really appreciate you all taking the time to come here and answer these substantive questions today. Thank you so much.